Did I know the rest of
Well, Clarence, yeah.
them? Okay, that's okay.
Thank you.
Okay, glad you made it. I just have one quick, just a reminder to the town of cell phone and electronic devices to be start in the less than 2 minutes. Thank you.
Yeah.
I'll check the news. All right. All persons having business before the honorable trustee session, down the back of the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable court now in session, please be seated, come to order.
Good morning and welcome to the District of Columbia Court of Appeals. We have 3 cases on our calendar this morning. The first case is 22 CM 611, Estefanos T. Medin versus the United States. Counsel, when you're ready, if you'll come to the podium and introduce yourself and let us know how much time you would like for rebuttal.
Morning, Your Honors. My name is Tom Burgess.
We're having a little trouble hearing you. I don't know whether you need to speak up a little bit or move the podium up or speak into the microphone. Thank you.
I'm Tom Burgess. I represent Mr. Medine. I would like 3 minutes for rebuttal. May it please the court. The constitutional right to a jury trial comes from our reluctance to put in the hands of one judge a person's life and liberty. The right to have a gun is fundamental to our liberty and central to our ability to protect our lives and the lives of others. Because of the decision of one person, my client lost that right. And he lost that right for 5 years because at the time of the alleged offense, the offense qualified as interpersonal violence under the code as it was in 2020, and therefore he was subject to the 5-year ban. I also think that he was subject to.
How do we know that he was subject to the 5-year ban? I mean, I understand your clarification about which version of the statute we're reading, but the court never said anything about the statute and didn't give any temporal limit to the ban that it announced. So how do we know that that's what the court was imposing on him? Or are you saying it doesn't really matter what the court said, the statute was out in the world and it applied to him, and so therefore the jury trial right was triggered?
I think the second point is stronger. It's by virtue of section 141001, it was interpersonal violence, and then by virtue of this, the assaults, the gun ban, I think that he immediately became subject to that ban upon conviction.
And so you would have known that ahead of time, that that was a potential penalty, correct?
Yes, trial counsel would have known that. And if I may address the standard of review, I do think that the argument that he should get a jury trial was a preserved argument in support of his claim that he was entitled to a jury.
I mean, the line between a claim and an argument is, of course, a murky one, but what's your response to the following line of thinking? The motion that asserted a right to a jury trial asserted it with respect to a particular count, the misdemeanor sexual abuse count. And that count then was dismissed. And if whatever line one is drawing between arguments and claims, one could at least conceivably say, even the claim was misdemeanor sexual assault entitles me to a jury trial. That was addressed. And then there was no argument or claim, depending on how you use those terms, with respect to whether simple assault provides a predicate for a jury trial.
Well, I think that's incorrect because the record shows that the defense counsel also argued that a jury trial would be required because additionally to the misdemeanor sexual assault, just the domestic violence count would have been deportable.
I'm not sure what you mean when you say domestic violence. You mean that the argument was made that simple assault itself, even if that was the only, if it arose in a domestic violence setting, would have been deportable, and therefore the defendant was entitled to a jury trial even if the only charge was simple assault. Is that what you're saying? The defense theory was a trial?
Well, not simple assault per se, but simple assault because it was domestic violence.
Understand the circumstances of this case, in your view?
Under the circumstances of this case, I'm sorry, are you asking my opinion?
No, I'm asking what your understanding of the argument
Yes.
that trial counsel was making.
My understanding of the argument was because it was a crime of domestic violence.
You start getting me confused when you say it there. I'm just not sure what you mean by
Sorry.
it. What?
Because the domestic assault that Mr. Medine was alleged to have occurred, which was a simple assault, but occurred in the domestic violence context, that qualified as a deportable offense.
That argument you're not reiterating here, though.
I'm not reading that argument, but I just push back against Your Honor's question, which assumes that the only claim that my client below raised was that he was entitled to a jury trial because of a misdemeanor sexual assault. He also raised the claim that he was entitled to the jury trial because of the simple assault, which was a domestic assault, and therefore would have entitled him to a jury, was his argument. But I agree that the line between, argument supporting a claim or non-preserved argument is not always clear. I think one thing driving the decisions is to look at what the argument would have, how the argument, if it had been brought up below, would have affected the dynamics of the trial. And so here, I think that weighs in favor of considering the argument here as preserved, as supporting a claim. The government has not been prejudiced by the failure of trial counsel to make that argument below. The government is as in good of a position to respond to that argument as it is on appeal. And so if the exercise of plain error is an exercise of discretion and it puts form over, it's not formalistic, then I think the court should withhold plain error review.
I mean, you identify one consideration, but another one that crops up in settings like this is that if is to assess whether an objection that was focused on in one particular way is adequate to preserve a somewhat different line of argument, maybe different claim, depending on the terminology. One line of thinking there is whether the trial court's attention was adequately brought to the matter at issue. And if that is the prism through which we were looking, would you agree that there was really nothing in the trial court that would have brought the trial court's attention to the points that are being made now about gun disability and all that?
I would agree with the caveat that the trial court knew of this penalty because the trial court imposed it. So I think that would be a consideration also in considering whether plain error. But I think there are lots of cases where it's unclear that the trial court was really given a fair chance to respond. In I think it's West, which was the knock and announce case. The defendant's argument, the defendant did make a vague sort of claim at the beginning of the trial that there was no refusal to let the police officers in. But then at trial, the counsel argued that there was never any knocking and never any announcement. So it seems like in that context, the judge would have been justified in focusing on, or not focusing on, the initial argument that the defendant had made. And
another line of thinking that comes up is that part of the reason for plain error standard to review is that you want to encourage folks to make an objection at a time when, if they're meritorious, they can be addressed. And that line of thinking also seems potentially relevant here, because if your point is a good one, and we assume that the trial court would have recognized it as such if it is a good one, then instead of wasting everybody's time with a non-jury trial that would then have to be sent back and done over quite a bit later, things would have been done right the first time. And so what's your take on the idea that particularly in a setting where nothing would have kind of directed the trial court's attention to, Second Amendment gun ban, collateral consequence. It does seem wasteful to have that issue raised for the first time now, rather than in a timely way where then it could have been done right if that's the way it needs to be done.
Yes, Your Honor, I see that point. And I think part of that, first of all, I don't think there's any sort of reason to believe that the trial counsel was participating in any gamesmanship in this case. And so I take the point that it might be wasteful, but I do think that sort of piecemeal appellate litigation is also wasteful. The issue has been briefed. We're hearing oral argument, and it would be wasteful to, at this point, not or prejudice the claim with plain error review when it had no effect on the practical dynamics of the trial.
Well, except for the fact that you went through a trial with a judge as the arbiter instead of a jury. Can I just ask one question, circling back to your response to Judge McLeese earlier? I thought I understood you to say, look, our claim for a jury trial before the trial court wasn't just tied to the misdemeanor sex abuse count. It was broader. But I'm looking at the record documents. It's at the PDF on page 60. And I just don't see, it does seem tied to the misdemeanor sex abuse count. I'm not seeing where you indicated that the assault charge would on its own trigger a jury trial, right? Am I missing something?
I don't have the page number. I'm sorry. I can try and look at that on rebuttal and get something
would be
more
great.
specific.
If
for
we
you.
could just move quickly to the merits then, because we're running low on time. Your argument is your client had a Second Amendment right to bear arms that was compromised, and that makes this crime, that restriction in conjunction with the maximum penalty of 6 months incarceration, which would otherwise make this a petty offense under Blanton, tips the scales, right? Here, the restriction on the gun possession is 5 years. It's not a permanent ban. And it's also, geographically restricted. It's within the District of Columbia. So I'm wondering if you can talk to me about why you think that sort of limitation that's temporarily restricted and geographically restricted would elevate this in Blanton terms to make this a non-petty offense, a serious offense.
Well, I think it's an enumerated right in our Constitution that.
Let's take that as a given. Right. But I don't think, well, maybe I shouldn't assume. If Mr. Medine had been told you may not possess a gun for 6 months, do you think under Blanton that would trigger a right to a jury trial?
I don't concede that it would not necessarily.
Well, if being incarcerated for 6 months doesn't trigger a right to a jury trial for up to 6 months, do you think the Second Amendment rights are more important than liberty rights?
Well, Blanton says that we look at the collateral penalty in conjunction with.
Right, I understand that, but I just was, I got the sense from your briefing that you were arguing any restriction on the right to bear arms would trigger a jury trial. And that seems like that couldn't be right under Blanton, right? If 6 months of incarceration doesn't trigger a jury trial, then presumably 6 months of restricting someone from possessing a gun wouldn't trigger a jury trial, just standing on its own. Do you agree with that?
True if it's either or, yes.
Okay.
Well, isn't it either or though in any event, because they're not going to let you have your gun in jail. And so
Sorry,
it's sort of intrinsically, I mean, if it was, you can't have your gun for 6 months after, for 6 months after you've been in jail for 6 months, then it would be additive.
And that's what I meant. That's sort of what I meant to bring up, like with the I think the 90-day license in Blanton was sort of, on the one hand, I don't think it was clear whether that would run at the same time as the incarceration. And so the court said, if it does, then it's irrelevant. And if it doesn't, then, and sort of the court didn't say, well, 90 days is de minimis. The court said he can get a restricted license within 45 days. And I don't think that.
Can I just make sure, I want to make sure I ask about Noctegal and not so much about what it held, but about the implications of your argument. I think it's true in Noctegal, although it wasn't made very clear in the Supreme Court's opinion or in the briefs of the Supreme Court, that it is a permissive condition of probation that you have a firearms disability for the period of probation as a matter of kind of federal probation law. And I assume it's true, though I haven't checked this out, that like in DC, you could have up to 5 years of probation for a misdemeanor. If those things are true, and I think they are true in DC, well, the second of those two things is true in DC. Does that mean that all federal misdemeanors are jury demandable? Because every federal misdemeanor faces the possibility of, as a condition of probation, a 5-year gun ban. And if your argument is that just facing that possibility makes an offense serious, I think it follows, but I'm curious in your response that all federal misdemeanors have a constitutional right to a jury trial.
Right. I don't think that's, I'm not willing to concede that that's not true or to avoid those consequences. And I think that has to be understood in the context of the vast majority of states give people the jury trial. And so, however things have been working in the past, there's a new sort of order after Heller, McDonald, and Bruin. And so I'm not ready to concede that that would be sort of a sort of, I know Your Honor is not saying this, but that would be sort of a ridiculous consequence or an unsustainable consequence.
And may I take you in a slightly different direction? So when we're looking at the Blanton analysis, something like deportation, or if it's a physical removal, permanent removal from your community, you can't come back into the United States writ large. And with a sex offender registration, that follows you, whether you go to the district or California or Wisconsin. Here, if the defendant wanted to leave the district, we would have no ability to restrict his ability to have a firearm. And so it seems like the sort of geographical magnitude of this restriction is quite different in kind than that we see with immigration or with SORNA. And so what is your response to that?
My response is, I would point to 922 G9, I believe, in the federal gun ban, which I believe says applies where somebody has been convicted of domestic violence in another state. So I do think that this conviction could follow my client around to other states, or maybe at least in federal jurisdictions. But if I could come back to Your Honor's question, I think even in Washington, D.C., it's substantial to say, even in your home, you can't have a gun. No matter how far away you are from the complainant, you can't have a gun. It's that's substantial under the case law. And so I do think that shows the seriousness of the penalty. I see my time is expired.
I don't want you to run away from the podium. I just wanted to be mindful of the time. I did want to ask, there was another case, another Second Amendment case that was argued before the Supreme Court this fall. And as you alluded to, sort of our understanding of Second Amendment rights is evolving. And right now, if the Supreme Court were to decide Rahimi tomorrow, that would be binding case law that we would consider, even if this were reviewed for plain error. So do you think that there is a benefit for us to consider what the Supreme Court is going to say in Rahimi? Or do you think that we can decide this case without waiting for the Supreme Court?
I think, Your Honor, that the case can be decided without waiting for the Supreme Court decision. My primary reason is I don't think the fact that a fundamental right can be limited detracts from the seriousness of depriving somebody of that fundamental right. So I see the pending case as sort of limiting the gun rights, at least to particular members of society. And I was also point out, I think that case is in the context more of the second point raised in the court's order. I think it occurs in the context of somebody being deprived of a gun under some kind of restraining order before trial.
For sure, right? It doesn't deal with jury trial rights, and it doesn't deal, it deals with someone who is subject to a CPO. But there was a lot of discussion at oral argument in Rahimi about the contours of the Second Amendment right and who enjoyed the benefit of that right at the time of the founding and who did not, right? And on one side of the equation, the Solicitor General said, law-abiding citizens enjoy the Second Amendment right. On the other side of the equation, she said, well, felons, which your client is not, and people who suffer from mental illness do not have the full benefit of or any protection from the Second Amendment. It's not entirely clear. So I was just wondering whether you were of the view that that might be helpful to you in this case, or whether you think that this case need not turn on whatever the Supreme Court says in Rahimi.
I don't think it turns, because I see my client as not having been properly convicted. So he wouldn't fall into any of those categories, even if it was not just felon, but even if it were misdemeanors. My client is not a misdemeanor because he hasn't been properly convicted by a jury of his peers. And at the time that he should have been given that right, he faced the 5-year ban. And to me, that's enough to have warranted the jury trial.
All right.
Thank you.
We'll let you sit down now and we'll get you back up for questions on rebuttal.
Good morning, Your Honors. May it please the court and opposing counsel, Chim Namso Kalu on behalf of the United States. Your Honors, the government is asking the court to affirm the trial court's judgment in this case. And there are two overarching points to that request. The first is that we think that the court should apply plain error review in this case. In a situation like this, where in the trial court, Mr. Medine had the burden to overcome the presumption that simple assault is a petty offense, and where the only attempt that he made to do so was via the deportation consequences that he would have faced had he been convicted of misdemeanor sexual abuse. It seems that coming to court at this late hour is too late. The trial court was not apprised of this argument about the temporary prohibition on his ability to possess a firearm, and so could not.
The second part of that is definitely true. And just back on the topic that I raised with the opposing counsel, and looking back at his motion, I think I missed it the first time through, but his motion in the trial court does on its first page say if Medine is convicted of even one count of sex abuse, bracket in this above reference case, or alternatively of simple assault, he could be rendered deportable. So there is, at least in his motion, a reference to the idea that simple assault, not on deportation grounds, not on Second Amendment related gun disability grounds, but there was at least some suggestion that simple assault would be a predicate. And in fact, I see that the United States' motion addressed that, and the trial court also addressed it on the merits. So to the extent the premise of my question was that the request in the trial court was really only focused on misdemeanor sexual abuse. It seems like maybe that's not quite right. Do you agree with that?
I would agree with that, Your Honor, but what I think does, it is still true. And I do see it's I don't have the PDF numbers, but record document 15 at pages 1 to 2 is where Mr. Medine made that argument. The government's response, the government's understanding of the claim he was making with respect to simple assault was that the simple assault as a domestic violence, and putting that in scare quotes, offense would subject him to deportation. And the government's response, and the trial court agreed, was that simple assault is not a crime of violence, as that term is understood under the Immigration and Nationality Act. So the government and the trial court were still looking at the simple assault charge through the lens of the consequence of deportation, and not through the lens of whether there would be a collateral consequence of a temporary, peripheral limitation on his ability to own or possess a firearm. That is something that was never raised in the trial court and was not raised until his briefing before this court. And again, it was his burden in the trial court to overcome the presumption that he was not entitled to a jury trial for the offenses with which he was charged.
If I could move you to the merits of the Blanton analysis. So here it's a 5-year disability on firearms ownership. What if it were a lifetime disability? Do you think that would change the Blanton analysis?
I think that would be a more difficult case. It's certainly not this case. What I think distinguishes the firearms prohibition, temporary or lifetime, as your honor's question suggests, from the categories of consequences that have been deemed serious enough to convert a petty offense into a jury demandable offense, is the life-altering impact on a person's life. So in the
Why doesn't compromising someone's right to bear arms, as the Supreme Court has discussed that right in Heller and Bruin, as they discussed it from the bench in Rahimi, compromise and abilities, I don't know, now I've forgotten the exact phraseology that you just used, impinge on their life in a critical way. I mean, it seems to me actually that the government really has to concede that the temporal limitation matters, that the answer to Judge Ali Khan's question is that a lifetime ban absolutely would trigger a jury trial, right? Like we're somewhere between, well, how long does the restriction have to be? And we're somewhere between 6 months. If it's 6 months, that's probably not enough under Blanton, but 15 years, right? Under Richter, right? That was a license suspension. That triggered the jury trial, right? So somewhere in between 6 months and 15 years. And, a license suspension, you don't have a constitutional right to drive a car, but you do have a constitutional right to possess a gun. So I would like to hear, like, what is the government's position on a 5-year restriction? Why don't you think that being able to have a gun in your home for the right to defend yourself would not be serious enough under a Blanton analysis, given what the court has said recently in Heller and Bruin?
Certainly. And I just want to be clear in talking about the lifetime ban, I was just wanted to be careful before conceding anything, since that's not what is on the table, and instead it's the temporary 5-year ban. But what I think distinguishes the 5-year ban from deportation and sex offender registration, aside from or perhaps I should say, in addition to the fact that it's a 5-year temporary ban, is again the life-altering nature of the consequence. And what I mean by that, in Bedeau, this court talked about and this is at page 1250, the fact that deportation is a forced physical separation of the defendant from American society, and that the person is required to leave. In Fallon, in the context of sex offender registration, the court discusses and this is at 496. The serious negative consequences, including social relationships, education, employment, psychological health, humiliation and isolation, jeopardized employment. Those consequences touch every aspect.
I get that point, and to the extent your point is that a 5-year making it a crime, one thing you face is that under DC law, it is a crime for the next 5 years for you to carry a gun in DC. That's not as bad as what was at issue. That's not as serious a collateral consequence as what was at issue in Bedeau and Fallon. That tells you that Bedeau and Fallon don't dictate the outcome, but your mode of reasoning seems to be the only way the defendant could win is if the collateral consequence he's pointing to is as bad as those. And it's not like we announce a test in Bedeau and Fallon, life altering, the collateral consequences must be life altering, nor has the Supreme Court suggested that. So I'm not sure that you get all the way to where you need to get. Maybe under the plain error standard, if it's applicable, you get where you need to get. But in terms of the merits itself, just showing, if we were persuaded by it, that it's not as bad as the collateral consequences in Bedeau and Fallon, doesn't necessarily tell you whether, nevertheless, it is sufficiently serious to tip something that's already teetering on the edge of a non-petty offense over into a constitutionally jury demandable offense. So it seems hard also to argue that under our modern understanding of the Second Amendment, that the individual right to keep and bear arms is not an important one. So I assume you will concede that's true, that this is an important right that is being limited.
I don't disagree with that, Your Honor, that it's an important right, but so too is the right, for example, to live where one wants to live. And a standard condition of probation for any offense in the District of Columbia is that before a person who's on probation can leave the District of Columbia, and by that I mean leave the district to reside elsewhere, they have to clear that with their probationary officer. And that's on page 2 of the JMC.
Does that make, I'm not sure why that's a good point for the government, right? I mean, if he's under probation and as a condition of probation, he can't possess a gun and he's also subject to this criminal statute saying if you do possess a gun in 5 years, you can be convicted. That seems to make this worse. I do want to go back to Rahimi. I mean, in the argument in Rahimi, the Solicitor General seemed to concede that there is no historical tradition of temporarily disarming misdemeanors. And I understand that there's no standalone challenge to the gun possession statute here, but I'm not sure why that wouldn't color our understanding of the seriousness of this consequence, right? If we think that actually this statute is on constitutional thin ice and really does compromise a fundamental right, that would seem to make this consequence quite serious for blatant purposes. Do you have thoughts about that?
Yes, and I hesitate to speculate too much about what the outcome or impact of Rahimi would be without.
I'm just talking about what the government's position was before the court. And the government's position was, look, for felons, people who are mentally ill, I think the list included loyalists, rebels, minors. Those people may be divested of their Second Amendment rights, but people who have not been convicted of crime, which Mr. Burgess argues, look, that was my client's position before he went to trial. And even after he went to trial, he was just a misdemeanor. So, I'm trying to figure out why the government thinks this wouldn't be so serious.
So for that, there's sort of a two-part answer to that question, Your Honor. Going back to Noctegal, the court did discuss a 5-year federal term of probation, which
said
included
nothing about the guns. I mean, the opinion cites a statute that the statute references restrictions on gun possession, but the opinion in Nachtigal itself does not discuss that restriction at all. And I just don't understand how the government can argue that the judicial mind was focused on that restriction in Nachtigal.
The court did not specifically certainly mention the gun restriction, but it did specifically state that there were at the time 21.
Right, and it only specifically identified 5 of the 21 and just sort of waved away the other, right? Nobody was talking about those. It's not clear. I mean, I didn't go back to look at the briefs, but it's not clear that any of the litigants raised those, right? And argued that those restrictions impacted the jury trial right. I don't understand how the government can say that that was an issue in Nachtigal. And that we should consider that in any way persuasive, much less a holding.
So, and what I would respond, Your Honor, again, that's just the first part of the answer, and that is sort of context for the way that the Second Amendment rights in it as collateral consequences have been discussed since that time. So certainly the Heller decision didn't say anything specifically to contradict what we think is the clear implication of Nachtigal's reference to the federal discretionary probation conditions. But second, since Heller was decided, this court has decided en banc Badeau.
Why would Heller have talked about Nachtigal?
I'm not saying that it would or should have, but just
right?
rather.
I mean,
that
Nachtigal is 1993, I think.
Yes, 1993 decision, Your Honor.
Right.
My point is just that decision discusses the right to bear arms, but does not discuss how important the right to bear arms is in reference to what collateral consequences of convictions. What decision did discuss that, we think signaled this court's view of that was Badeau, which we cited footnote 32, where this court discussed an Arizona state decision called Strossen and noted that in that case, the Arizona Supreme, I think it was the Supreme Court, I believe the Arizona Supreme Court said that it did not, that the temporary loss of I think, just give me 1 second, Your Honor, so I can get the quote. I apologize. That court said, and this court quoted that decision, that while admittedly very important to some people, that is the right to carry firearms, did not present the type of universal grave consequence that we have found in cases invoking a right to a jury trial. And this court looked at that language in contrast to what was a grave consequence of deportation. And subsequent to that, just weeks later, admittedly in an unpublished decision, this court in a case called
Before
It-
you cite that, can I ask you about that? Because I would have thought that the court's rules preclude your reliance as precedent on an unpublished decision of this court. So I think Rule 28G of our court rules.
Which is why I preface that by saying that it is unpublished, but what would.
Well, but I think the rule precludes citation to it. So are you not familiar with the rule? Or?
I apologize for.
I don't mean it critically. I'm just trying to make sure in any event, my reaction is that I think our rules preclude your reliance on the unpublished decision in Jenkins. So that's just my reaction, but I give you that reaction for what it's worth.
Certainly.
Right.
And
They are
this-
not published to the world, and so they have no precedential effect on the outside world or on this court. So I think you can move on.
Yes, and so leaving aside then Jenkins, we still have the en banc court signaling in footnote 32 about the.
I mean, it's dicta, right? We weren't focused on that issue either in Badeau. And so it was a reference point. It's not a holding.
I think it was a reference point in response to the dissent.
What are we supposed to do with it? Are you saying we're bound by it?
No, Your Honor, I'm saying
Okay.
that the court can look to the reasoning there. And that was, Your Honor brought up the fact that the firearms.
And it's pre-Bruin,
But post-Heller.
post-Heller, but I mean, a lot of time went by, right? Heller was decided and people thought, what does this mean? And the Supreme Court didn't really say what it meant, and it waited quite a bit of time to take another Second Amendment case. And then finally it took Bruin, and it essentially told us we meant what we said in Heller, and here let us say more about this robust right to the second to bear arms. So
Yeah. I don't mean to interrupt, Your Honor. Sorry.
I don't find that footnote in Badeau is terribly helpful, but I would like you to be able to continue your argument.
I see that my time has run.
Please take a little bit more time to finish what you need to say.
Certainly, thank you, Your Honor. What I would say at this juncture is just that the way that this litigation has proceeded, and the tricky, intricate nature of these questions, the fact that there are various Supreme Court cases that are still out for decision, that were, cases that were decided in between the bench trial in this case and briefing that haven't been cited by the parties, takes me back to our initial point, which is that we think that plain error review is the appropriate standard of review to apply in this case. Because Mr. Medin did not raise the temporary gun prohibition as a basis for entitling him to a jury trial, we are left at this point without a record, without the benefit of briefing on that issue. Certainly we have briefed the issue, certainly the court has looked at the issue, but there are a lot of moving parts that perhaps could have been better elucidated if we had a record that dealt with the issue. And certainly, to Judge McLeese's point, when my friend from the other side was up here, if there had been something else that could have been done to ensure that we did not go through the process of a bench trial and go through this entire appellate litigation process, we don't have the benefit of that, because Mr. Medin did not, we believe he did not carry his burden to overcome the presumption that simple assault is a petty offense. And that is we still think that on the merits, that our arguments are sound, but ultimately we think that plain error review should apply in this case. And so we would ask the court to affirm the trial court's judgment if there are no further questions. Thank you, Your Honors.
Thank you, counsel.
If I could just pick up on that last point.
We're just going to give you 3 minutes, and I think that's what you asked for.
Yep.
Yes. Okay.
In Lewis, the trial court said, don't worry about adding the penalties together, which would be over 6 months, because I'm not going to sentence you to over 6 months. And the Supreme Court took it on. It didn't remand it to develop some kind of a record, because there was no need for a record, and there's no need really for a record in this case. And I would point out that, like in Escondido, that was the facial challenge. It wasn't as applied. So there wasn't really a need for factual development. And I would point out, sort of in the civil context, cases like Mills that was basically in the context of a JNOV. So the court was basically assuming all of the facts and just looking for anything that would have shown that the lawyer was not guilty of malpractice. And so I think
But I think what's slightly different is in this case, we were all, or the lower court and the parties were focused on the deportation consequences. No one was thinking about the firearm disability. And so here, we don't think the judicial mind has been put to the Blanton analysis. And why wouldn't we benefit from having the trial court's view on that in the first instance?
Well, for the same reason that the Supreme Court didn't need to be benefited by the trial court's opinion in Lewis. And I would point to Brown. In that case, the claim was inadmissibility, which is somewhat general, but the arguments were quite disparate. I believe they were, one was a Drew analysis, and then the argument below was a Drew analysis, and then on appeal, the argument was credibility. So I just don't think the touchstone for plain error is sort of like, I mean, it's an important factor, but fairness to the judge, ability for the judge to rule is not sort of it's not a per se rule. And so I think in these circumstances, it makes sense to not apply that level of review. The phrase was used, life altering. I think in some circumstances, not having a gun can be life altering, or even if not presented with an attack, it causes some people to be very anxious. And to come back to your honor's point, I think it's possible that any restriction on gun ownership would require a jury trial, but I do think that I do think that 5 years is too long. How the court draws that line, I can see that there is difficulties, as there always is in line drawing. But the Second Amendment, it's not a second class right. It's often compared to free speech. In the context of gagging somebody, that's during a trial. I know it's not a perfect analogy, but even in that situation, the courts take it very seriously and they try and make it narrowly tailored and only for no more than it has to be effective. My time is up, so I would just ask that the conviction be vacated. Thank you, Your Honor.
Thank you, counsel. Thanks to you both for your arguments, and the case will be submitted. The next case on our calendar today is 19 CF 546, Sean Tyler Green versus the United States. Counsel, when you're ready.
Thank you, Judge Easterly, and may it please the court. My name is Greg Lipper. I represent the appellant, Mr. Green. I'd like to reserve 4 minutes for rebuttal. I want to start by focusing on the issue of the waiver of Miranda rights, because here the detective gave Mr. Green 2 conflicting warnings. There was the standard card, the written warning, in which recited our traditional understanding of the Miranda rights, the right to remain silent. You have the right to consult with counsel now or during questioning and so on. But then also while he was going over those, added a conflicting and sort of overriding oral warning, which modified in particular, the right to counsel, because clarifying that there would be no right to counsel in the interrogation room, that the right to counsel would come later. And so because there was a conflict between the written warnings and the oral warnings, it was incumbent upon the police to make sure that the defendant understood exactly what his rights were and were not going to be in that setting. And that is reinforced by the fact that it's the government's burden to show a knowing and intelligent waiver.
Can I ask you to distinguish between 2 different points? There's one doctrine that governs the adequacy of the warnings themselves. And there's a related question, which is after the warnings, assuming they were legally adequate, a waiver was knowing, intelligent, and voluntary. And some of the same circumstances can go to both of those things. Are you making both those points? Are you saying that because of the concern you just raised, that really the warnings were legally defective? And alternatively, for the same reason and many others, in your view, any waiver thereafter was invalid, and for related reasons, any confession was involuntary in the Fifth Amendment sense?
So I'm not saying the fact of the conflicting warnings in and of itself is inadequate, but I think in these circumstances, we also have indication that there was confusion generally and also about the relationship between the two warnings. I think,
Mr. Lipper, why aren't you arguing that these are inadequate? I mean, they seem to me to be sort of wholly confusing and falling back on each other.
I mean, I think my reading of the Supreme Court's case law, which is then sort of incorporated in this court's decision in David Robinson, is that the fact of the oral, the fact of the more or the narrow or somewhat conflicting oral warning in and of itself is not a Fifth Amendment violation. But I think here we have, I mean, whatever the answer to that question in the abstract, here we have Detective Patterson gives the written warning, then modifies it by the oral warning. He then asks Mr. Green, do you understand? And instead of saying, yes, I understand, Mr. Green says, is that what's on this paper? In other words, whatever.
Well, Robinson was not the first time that we have looked at modified, or we euphemistically call it embellishments to the warning, right? We looked at this in Henson, which was right after Duckworth. And we effectively said, don't do this anymore. And if we see a pattern of this, that's going to be a problem. So I sort of reiterate my question, the question that Judge Alikhan poses. Shouldn't we be looking at the actual text of the warnings just on its face and say, there's a form. By general order, the police are supposed to read the rights on the form. Deviation from the form warnings is problematic.
If that is what the court wants to do, I do not want to stop you. My point is simply, we have additional factors in this case, which I think makes it clear that the government has not met its burden, because there was never an instance in which Mr. Green assented to understanding the operative embellished oral warning. In response to the oral warning, when he was asked, do you understand? He said, is that what's on this paper right here? Sort of kind of almost like a student in a law school
And
class.
he answered yes, and the correct answer would have been no. That's your point?
Well, that's one of the points, right? That when he was then faced with is that what's on this paper? Detective Patterson said yes. And then he said, then he went over the written warnings again, which were actually not the operative embellished warnings. And then, if you take a look at the hearing below as well, you can see that the government's questioning of Detective Patterson is really eliciting the written waiver. It's talking about, was he looking at the written waiver? Was he looking at the written waiver? And the trial court's analysis likewise was focused on the written waiver. There seems like there are real questions about even confusion about the written waiver. But when you start with written waiver with conflicting oral embellishments, and at most you have maybe is that what you're telling me on the written waiver? The combination of those things, prevents the government from meeting its burden.
Can I ask you, you say conflicting oral embellishments, and I mean, part of the Supreme Court's decision in Duckworth versus Egan, I think, was to suggest that language pretty similar to what's on page 822 that's in the nature of an embellishment,
Right.
is not conflicting, and that if put in the context put in an appropriate context, is not fatal to the validity of a waiver. So I wonder why you say conflicting. What was said was, certainly an embellishment, and I would have said, and I think you can take away from Duckworth versus Egan, considered in isolation, potentially confusing embellishment. Duckworth versus Egan said, in the circumstance of that case, we don't think there was confusion as a whole. And just so what was said was, you have a right to talk to a lawyer before questioning and to have him with you during questioning. That part is good. I mean, it's may not be exactly what's on the form, but that's a good way of describing that. I think you would agree. And then gets the part that seems potentially problematic that Duckworth said in the context of that case was not fatal, which is, we're not going to do that here. We don't have lawyers just lined up waiting outside. So, that's not how that's going to work. And then after saying that part, which again, Duckworth versus Egan said, in its circumstances, is not fatal, then you wrap back around. This is on page 822 of the transcript. If you want a lawyer, you want to be provided in court. So again, sort of the lawyer is down the road, but then wraps around at least to, if you want to answer questions now without a lawyer present, you can stop answering at any time. You also have the right to stop answering any time until you talk to a lawyer. So again, kind of wraps back around to what Duckworth versus Egan, I think, would have treated, maybe if that was all we had, as enough. Not that it's conflicting. The Supreme Court didn't think that was all conflicting. They thought it was maybe potentially confusing, but
Right.
clear enough if put in context.
I don't think I meant conflicting as a term of art, so I'm fine with calling it a potentially confusing embellishment. At the very least, there is a tension, because from the written warnings, you would get the impression that, 12 minutes in, you know what, that's a really hard question. I'd like to talk to my lawyer before I go on. Is the impression you get from the written warnings. From the oral warnings, what you're told is no, it's all or nothing. And so,
And can I just, because I had an aspect of what you said today, I hadn't really zeroed in on in the way that you presented it today. So probably my failing, but on the passage that then happens right after, where Mr. Green says, "Huh," and then the detective asks, "Have you read or had read to you the warning?" And Mr. Green says, "Was it this paper?" I assume referring to the PD-47 form.
right.
And Detective Patterson says, "That's what I just did." Your point is that's just not accurate.
That's correct.
What was done was an oral statement that at a minimum added potentially confusing material. And in any event, it was not simply reading the PD-47. So that's just not accurate.
That's exactly right. Whether you say it's conflicting or not, it's certainly a material embellishment on the rights that is, and given that that's the situation, is something that Mr. Green needed to understand and did not, because after the oral embellished version of the rights, he asked, "Is that what's on this paper?" And then Detective Patterson said, "Yes, that's what I read you." And that is in fact not accurate. And thus, even if Green then went back and reread the form 100 times, he still hasn't gotten the critical oral embellishment, which is actually what is kind of controlling his actual rights. And that is, then you add to that the fact that he's asserting confusion, that he's behaving erratically, and it makes it even more problematic. But at the very basic level, it is the government's burden to show a knowing and intelligent waiver. And when Mr. Green's response to being asked, "Do you understand what I just told you?" was, "Is it on this paper?" It was essential for Detective Patterson to clarify, to reiterate what it was he said orally, which was not actually strictly what was on that paper.
Can I ask you just to put the full context of the Miranda waiver out? I'm focused then on page 824, where the detective is walking through the questions on the rights card with your client.
Yes.
And seems to be walking through them one at a time, and starts by saying, "Do you wish to answer any questions?" And Mr. Green says, "Might as well," says he's confused. Again, some ambiguity about what he's confused about. And then Detective Garner, I guess it is, rather than Detective Patterson, chimes in and starts trying to say some further explanation of what these various rights mean. And then Detective Patterson says, "Anytime you don't want to talk to us, you can stop." That in isolation, somewhat, accurate as far as it goes and not problematic. And then on the fourth question, what Detective Patterson says is, the last question is, "Are you willing to answer questions without having an attorney present?" And then what Detective Patterson says is, "And again, we don't bring attorneys in here. So you aren't going to have an attorney present anyway."
Right.
And that's the last thing that is said, other than, "Okay, sign here." That's the last conversation that's had about how the right to have a lawyer present before being interrogated and during interrogation is discussed.
So I would say a couple of things. I think for even that is, I think, quite an abbreviated, compression of the more thorough oral embellished rulings. And I think the key point that is still missing from that is that at no point during the questioning. So in other words, I think still Mr. Green is still left from the written warnings, and even with that final preface to question 4, he's still left with the impression that he may at various points in the midst of the interrogation be able to ask for a lawyer. The other point I want to make, and Judge McClese, you alluded to, potential ambiguity about the source of confusion, which is that I think at the very least it is clear that it is clear from the record that the reason why he was there in the first place is not the only thing on his mind, because he repeats the "I'm confused" 3 times, including after Detective Patterson tells him not only what he's charged with, but what some of the evidence is, or what he says some of the evidence is. And the 3rd time he's saying he's confused, he's looking at the warnings, and he makes the statement, that's all a lot to take in, and that's after the warnings are being discussed. And so I think there's an overriding problem here. It's reflected in with respect to confusion and in several other areas we discuss in our brief, which was Detective Patterson was repeatedly confronted with circumstances in which a sort of reasonable person would follow up and make sure and clarify what was going on. And Detective Patterson each time declined to do that. And then when he was asked about it at the hearing, his answers were very conclusory. Why did you, he said, are you asking me brain-wise? What did you take that to mean? And he says, well, I didn't follow up. And then, follow-up question, did you take that to mean there was something sort of mentally? And witness says, I didn't take it to be that way. And he just says, why not? I just did not. And there's you have that with the medications, you have it with brain-wise, you have that with confusion. You have these things over and over and over in which something that would cause a person hearing that to say, what is the source of your confusion? Or what do you mean brain-wise? He never did that. And then
and that's a fair argument to a fact finder. It's a little, it's a standard review question I have for you, focused on confusion.
Right.
Because the trial court did say, that issue was teed up in the trial court. There are statements in here about your client being confused. What is your client referring to? Is the confusion really about why am I here? What is this evidence you're saying is against me? I don't understand why you think I am a suspect here. Or is it instead you're telling me all this legal mumbo jumbo about rights and I don't really understand what you're talking about? Which is it? And the trial court, in what at least arguably could be viewed as a factual determination, said, here's my conclusion. I think that the confusion was focused on kind of offense uncertainty, not rights uncertainty, if that's a fair way of labeling them. Do you agree that that's a factual determination that we're bound by unless it's clearly erroneous, or do you think that it's not really factual in character?
So I'm gonna say yes and no, and I'm not trying to evade your question. So let me try to if the court will allow me to speak beyond my expired time, I'll elaborate on that. So I think the specific finding that when Mr. Green said he was confused, he was referring to why he was there. I think that is a finding of fact, but of course it is still reviewed for clear error. And I think if you look at the reasoning, the trial court's reasoning was really focusing on the first expression of confusion. There were 3 expressions of confusion, and the only real elaboration, in terms of what followed from Detective Patterson came with the first expression of confusion. The fact that after the second expression and the third expression of confusion came after the charges had already been explained to him. And so, and that none of that's really addressed, and the third one was while he was looking at the Miranda card. So none of that is really addressed in the findings. So you have not only sort of what seems to be contradicted by the record, but there's no even attempt at explaining that. But more generally, I think you're still looking at this in terms of the ultimate legal question. The ultimate application of facts to law is in the posture in which the government still has the burden of showing a knowing and intelligent waiver. And so to the extent there are these repeated, at best ambiguities, what is the source of confusion? Is he referring to mental or cognitive limitations when he says brain wise? What were the medications or the withdrawals and how did they affect him? All of these things that Detective Patterson either didn't ask about or sort of very quickly moved on from during the interrogation without following up. And then at the hearing, not offering any reasoning for his sort of conclusions that, oh, I didn't think it was a big deal. I didn't think he was referring to mentally. I didn't think there was an issue. Why? Well, I just didn't think so. All of that does not suffice, given that is ultimately the government's burden to show a knowing and intelligent waiver. And of course, all of this is on top of the fact that the bulk of the discussion and instruction to Mr. Green was about the written warnings, when in fact the embellished and potentially confusing oral warnings is what he actually needed to understand. Unless the court has any additional questions.
Did you want to address your statutory argument or do you want to rest on your briefs?
Oh, on the gun charge. I'm happy to rest on my briefs. I'm also happy to answer any questions the court has. So I will defer to you, Your Honor.
For now, maybe we'll let you sit down and then you can supplement if need be in rebuttal.
Thank you, Your Honor.
Thanks.
Good morning, and may it please the court, Dan Lenners for the United States. The trial court did not err in finding that Mr. Green's Miranda waiver was knowing, voluntary, and intelligent. The detective read Mr. Green his rights. He did embellish them in ways that this court has repeatedly found do not render the warning unknowing or unintelligent, both in Robinson and in earlier cases such as Walls.
I guess if the relevant facts on that are, I mean, I'm with you if all we had was what was on, I guess, what it A 21 over to 22, which is, where I'm going to tell you about, you have a right to talk to a lawyer, and that's stated pretty well. And then there is this language about we don't do that here. So if you want to go that route, that'll happen later, and your remedy really is to just stop talking to us at all. That seems to me myself a little bit confusing, but the Supreme Court said in Duckworth versus Egan, if there is enough that clarifies that, that's okay. And we've said that in various settings, but I guess there are at least two aspects of this case that seem different from Duckworth and problematic. So I'm interested in your response to the weeds of that and what case you think includes features like that. The first is one that I hadn't really focused on until argument. I mean, the point was made, but it hadn't resonated in quite the right way, which is what your opponent argues is an inaccurate statement, where essentially when Mr. Green says, when asked, have you had your rights read to you? Have you read or had them read to you? He says, is that what's on this piece of paper? And Detective Patterson says, that's what I just did. And your opponent argues that's just not right. What's on the paper is different. And what was orally done was embellishment. So do you agree that that was really not precise, or that's really not accurate, not an accurate or clear response?
I agree that that's not an accurate or precisely accurate response. But what the detective then did was set the PD-47 in front of Mr. Green and gave Mr. Green the opportunity to read it. And Mr. Green appears to be reading the PD-47 as the detective continues to question him, including by asking him, do you understand your rights? And Mr. Green, after appearing to read, says, yes. So he says, yes, I understand my rights. And this is in a context of a defendant who has been arrested 7 times and has waived his Miranda rights 3 times before. And in context of the defendant.
Just make sure when you say, do you understand your rights? That's orally, you're saying on A23, do you understand your rights? Although, of course, he says he has, but then a couple lines later, he says, I have some questions. I'm so bleeping confused right now. And then to his credit, Detective Patterson then says what's confusing you and tries to clear it up a little bit. But the part I guess I'm also troubled by, I'm interested in your response to, is what happens on A24. Because then when Detective Patterson is walking through the rights card with Mr. Green, when you get to the 4th question, all he says is, The last question, are you willing to answer questions without having an attorney? We don't, we don't bring attorneys here, so that you aren't going to have an attorney present anyway. And what there isn't there is any of what the Supreme Court in Duckworth said was present there that was sort of rebutting or avoiding what could be the potentially confusing part of that answer. Because that answer in isolation, I would have thought, is really in the nature of, I mean, there's no point to answering yes to this question because we don't have attorneys here. So what case do you think is like this case in that respect?
I don't know that there's a case directly on point that's like this case. That this court said in Robinson specifically that this detective's embellishment to Miranda by telling the defendant, we don't provide you a lawyer here, did not intentionally obfuscate the standard Miranda warnings and leave that defendant uncomprehending of and inattentive to the Miranda right to counsel.
And that was really the part that was on A21. And I'm with you that if all that happened was what was on A21, you should win under Duckworth and under our decision in Robinson. But what happened in Robinson was the same detective, apparently misunderstanding perhaps the upshot of Duckworth, just thought, I don't even have to ask the fourth question. So I'm not going to ask the fourth question. We ended up saying, not asking the fourth question, that was fatal.
So I have other responses as well.
I have the concern that what happened here was not quite the same mistake that the detective made, but it was a similar one in that rather than simply not asking it, instead, when the detective gets to that with the defendant, he presents it as though, I mean, I'm asking it, but there's an obvious answer because we don't have lawyers for you.
So factually, the detective says, and again, we don't provide you lawyers here. So he's clearly referring back to his previous statement that you get a lawyer when you go to court the next day, which the Supreme Court and this court have found is an appropriate thing to tell.
I don't think that's quite right. I think that's an overstatement of what the Supreme Court said. I think what was, I think what was said in Duckworth was there's this language, but there's a lot of other things that happened, and on balance, we don't think that the rights were inadequately communicated. So if your takeaway, if you think our takeaway from Duckworth and Robinson should be what's on A21, just the part about that does not happen here. There is no lawyer here. We're not going to bring a lawyer to you. That happens when you get down in court. That happens when you get down in court. If you think that's all just fine to say, no concerns. If you think that should be our takeaway, then I haven't taken that away yet. So you should point me to where in Duckworth or in our cases I should be taking that away. I had read them differently to be, wow, that is potentially a problem, but it's not fatal where there are enough things that clarify and preclude what otherwise might be a misreading of that to mean this whole right to counsel during questioning is really not operative.
I agree that this court has never said it's perfectly fine. Duckworth does say, we think it must be relatively commonplace for a suspect after receiving Miranda warnings to ask when he will obtain counsel and that the advice simply anticipates the question. But also in the
I'm sorry, I just want to stick with Duckworth for a second. There's one critical difference in Duckworth and the rights that are read to the respondent in that case. And it's that the respondent is told, I know that I am not under arrest and I can leave this office if I wish to, right? So the fact that you don't get a lawyer right then when you're in the room, well, he's not under arrest. He can leave the room. He can go get a lawyer and maybe that's fine. Here, Mr. Medin is told, you are under arrest. You are not going anywhere. Would you like to talk to us? You have a right to a lawyer, but of course, we're not going to give you a lawyer. We're not going to give you a lawyer for some extended period of time till you go to court. Maybe tomorrow, right? So that seems like a big difference with Duckworth. But then I want to take you back to, well, go ahead and respond to me about Duckworth.
Yes, Your Honor, that was true in Rawls, in which this court said that a lawyer would not be provided until the next day, does not rise to the same level of potential confusion And that it was that embellishment was not alone enough to render the Miranda warnings ineffective. It was true in Robinson.
But this wasn't just next day. It was, you aren't going to have an attorney present anyway, which I think could be understood as you're not going to have an attorney writ large, not just you don't get one until tomorrow or until you go to court or until you're arraigned.
But at the same time, the detectives made clear to the defendant that he could ask for a lawyer and questions would stop until he was able to speak to one. Detective
Let
Patterson.
me take you to Henson, though. Henson's 1989 predates Robinson, not mentioned in Robinson. In Henson, there's also a similar embellishment. And we said, based on those facts, again, that, and we stressed the contextual setting is important for how this is set, what's going on. So, the warnings in Henson were, we held fairly apprised the appellant of his right to have an attorney present, but we said, we take this occasion to repeat an admonition expressed by us over a decade ago in reviewing another case in which an officer expanded upon the language of the standard Miranda warning. We noted that the recurrence of this question and decisions points up the unnecessary litigation that is created by embellishments on the essentials of Miranda. And then we stated, if in the future it should appear that this particular embellishment, you don't get a lawyer right now, on Miranda is becoming a pattern, we might well be required to examine whether it has become a tactic intended to confuse suspects on the Miranda rights, as the trial court found here. In other words, if it should later appear that such a statement is being used in a manner which may result in confusion on the part of suspects as to their Miranda rights, this may then require examination. There's a form. It's a standard form. What is the problem with a detective just reading from the form, particularly after we said what we said in Henson?
There is, of course, no problem with the detective reading from the form.
In fact, they're obligated to under the general order, right?
And it is the best practice.
Not just the best practice, they are mandated to use the PD 47 to read the rights,
But of
correct?
course, the question in this case is whether this defendant knowingly and intelligently.
Well, the predicate
favor-
question is, I think, as Judge McLeese identified, is whether or not the rights were properly read to the defendant.
I disagree. It's not whether they were properly read, Your Honor. It's whether the defendant was fairly apprised of his rights and they weren't somehow undermined or.
So the form is
vitiated.
following the form is unimportant.
It's not unimportant, Your Honor, but the Supreme Court has made clear that there is no talismanic Miranda warning. That as long as the defendant is told of the substance of his rights, there are no magic
Well,
words.
the Supreme Court, in talking to the nation, has said, we're not going to dictate to you how you should write your Miranda warnings. But the District of Columbia has a form that sets out the warnings. I think it's been the same language since 1973. And the police general order says, you must record these interrogations and you must read the PD 47.
Your Honor, I'm training detectives on the Fifth Amendment this afternoon, and I will pass the message along that there is a general order they must follow. I mean, it's happening at 3 o'clock. I'm happy to do it. But the question here, in
But
this
and
case-
I'm very glad to hear it. But I think we said that in Henson, it's not like I'm articulating something new. And so I'm wondering whether that impacts our understanding of what happened here, right? Were these warnings adequate if they didn't follow the form?
And they can, and the Supreme Court has made clear that they can be adequate, even though they don't have magic words. Duckworth found that even telling a defendant that you will not get a lawyer until you go to court.
A defendant who is not under arrest and is free to leave.
A defendant in Robinson who was under arrest and was not free to leave and who was told.
But
"You don't-"
Henson would predate Robinson, and Robinson didn't mention Henson.
And Rawls as well, which predates both from 1974, says that telling a defendant that a lawyer would not be provided until the next day does not rise to the same level of confusion. And so to answer Judge McLeese's question, if telling a defendant in Duckworth, we have no way of giving you a lawyer, but one will be appointed for you if you wish, if and when you go to court, it shouldn't matter the timing within the rights of that statement. Under any scenario, the defendant understands that he will get a right the next day or get a lawyer the next day. And thus, if he's going to answer questions there, it would be without a lawyer, but he nonetheless has the right to speak to a lawyer before answering questions.
Mr. Leonard, may I drag you back to the general order for a minute? I think I share Judge McLeese's framework of there being a predicate question of whether the warning itself is satisfactory. And I think one reading of that is, does it comply with the PD 47? I think you say no, as long as the individual is generally apprised. And so I'm wondering if you could give more content to that. You know, how much of a departure from the PD 47 does it have to be where we can assume that the defendant was not fairly apprised of what Miranda means?
I don't have a great answer for you because the defense never framed the issue as one of this embellishment undermine the rights separate and apart from it being a voluntary and intelligent waiver. But I think in general, my understanding from the cases I read in preparation is that if you tell the defendant they have a right to remain silent and then say something, you know, directly antithetical to that, but you can't really, you have to talk to us, that functionally undermines the right. But here, the defendant was repeatedly told, you have the right to speak to an attorney, including Detective Patterson, or excuse me, the Detective Garner saying that that if he wanted to speak to an attorney, they would stop questioning. If he wished to speak to an attorney, he would have the ability to. I'm sorry, I don't have the exact quote. So Detective Gardner on page A24 said, you have to stop answering questions until you talk to a lawyer. So they made clear that if he requested a lawyer, they would stop questioning him. And so it didn't.
Although what Detective Gardner said there, as quoted in the transcript, who knows, I guess, says because you can answer questions and you still have, it says right there that you still have to stop answering any questions until you still have to stop answering any questions until you have talked to a lawyer. That's not quite.
It's not crystal clear, but it makes the point, and she's pointing him to the warnings, which the PD 47 that he had in front of him was that if he requested a lawyer, they would stop questioning, or that he had the right to an attorney present to speak to an attorney before and during questioning.
Let me ask you a question this way. Let's take what Detective Patterson says from lines 21 to 25 on A24 and consider that in isolation. If that was all that the defendant was told about the right to counsel, would you agree that that would be constitutionally inadequate? I know that's not what happened here. I'm just asking you a question about the language, that language in isolation.
So I don't know the pages of the record well enough to know what your honor is omitting from what he's told about the right to counsel.
I'm not admitting anything. I'm just asking you, if you look at lines, I don't know if you have the transcript in front of you, but if you look at the transcript and you say, if you take lines 21 to 25 on A24, and this is a hypothetical case, obviously not our case. Imagine the detective told the suspect about the right to counsel, only that. You would agree, I assume, that that would be constitutionally inadequate.
I think that's right, Your Honor. The defendant has to be told that you have a right to the presence of counsel and to speak to, during questioning and to speak to counsel before answering any questions. And that those lines does not adequately inform the defendant of that right. But the defendant in this case was informed of that right. And again, to turn to the knowing and intelligent issue as the defense has framed it, this is a defendant who had previously been given and waived his Miranda rights 3 times. And the judge made a finding of fact that his statements of confusion, which were after he answered, yes, I understand my rights. His statements of confusion were about the reason for his arrest. And in fact, she reached that conclusion watching the video on her own, even before hearing testimony from the detective. And then the detective said that's how he understood the statements of confusion, were why was he there?
So if we think there's a sort of predicate level of satisfactory Miranda, can that be cured if you know that you have what your Miranda rights are and you've waived them before? If they drag me in and just, read me half of my Miranda rights, I know what they are, right? Does that mean I'm fairly apprised, even if the police officer didn't comply with the full PD 47 of the warnings?
No, Your Honor, I think it's a different question, which is the defendant has to be fairly apprised of the rights and.
At the time, it's not just in the ether. They might have at one point been fairly apprised.
Yes, Your Honor, and the defense has not framed the question as Your Honor and Judge McLeese have framed it, which is, were these rights adequately stated? But the knowledge of the rights does go to the knowing and intelligent waiver, as the Supreme Court and this court and other courts have repeatedly made clear. The judge's factual findings is subject to clear error review. And as we pointed out in our brief, there are many reasons why it was not clearly erroneous. And the defense, frames the standard of review as the government bears this heavy burden to prove a knowing and intelligent waiver. But the standard of review is in fact, we have to prove in the trial court a knowing and intelligent waiver by a preponderance of the evidence. And then on appeal, the trial court's factual findings are reviewed for clear error, and this court must view the facts in the light most favorable to sustaining the trial court's ruling. And so questions about, for example, what the defendant's mental illnesses were and how they work, are, you can't point at the government now and fault the government for not proving something on appeal that isn't in the record that the defense made. Turning to the felon in possession statute, I would be happy to address any questions the court has about the proper interpretation of DC code provision. But at the very least, given the significant textual differences between it and the federal felon in possession statutes at issue in Rahafe, and the DC and the legislative history of this code provision in particular, there was certainly was no plain error here in the trial court not instructing the jury that it must find the defendant's knowledge of his status. We think that the proper interpretation of the statute is the defendant need not know his status, much like the many state courts that have reached that conclusion under analogous state provisions. But the court need not reach that issue because the error was not plain.
Is there a case that goes the other way? I know there are lots of state cases that support your view, and I couldn't find one, and I'm just wondering if you're aware of one.
I don't believe I found one either, but I also wasn't trying to do Mr. Lipper's job for him. He's quite good at it.
And when you say it's not plain, you're of the view that, is it Rahafe? Is that how you pronounce the name?
That's how I pronounce it.
Okay, good. We'll do that together. That you think that the general principles in Rahafe are not sufficient to make the error plain, that it has to be tied to the particular text of the statute, and because the statute in Rahafe had a knowing mens rea in the text, that the court was applying to both the possession and the status, that makes this sufficiently different? Is that?
Yes, Your Honor, that Rahafe was fundamentally a statutory construction looking at the intent of Congress. And the intent of Congress in that case was, it said in one provision, whoever knowingly violates another provision is guilty. And then the court, as a matter of statutory construction, said, we have to figure out what knowingly violates means. And subsection A is pure statutory construction that says, to knowingly violate this provision, you have to know both possession and status. And particularly given that the status element comes before the possession element, it makes no sense to apply it to possession, but not status. And then it went on to say you have to have the vicious will, and we apply the presumption of mens rea to any element that distinguishes innocent from guilty conduct. But the DC code provision with no mens rea, with a history, with no knowledge requirement whatsoever, with a history that shows that when Congress enacted it, they knew how to make knowledge of status part of the crime and didn't. And when the court of this court never found a knowledge of status element, and the DC Council nonetheless reenacted the same language, shows that the council's intent was not to enact a knowledge of status requirement, but at the very least, it's not plain, given that Rahafe isn't a command that you must have knowledge of status, as the numerous state courts have found.
Well, I mean, setting aside the other state courts, I mean, Rahafe does, beyond its statutory construction discussion, it does have sort of a broader discussion about general principles of, criminal statutes aren't supposed to be, gosh, I'm losing the words, without a mens rea, right? There, generally, we presume that there is a mens rea that attaches to a criminal statute. And so there's this presumption that you're going to have a central requirement in criminal statutes, right? So it's not just a statutory construction analysis in Rahafe. And it seems to me that one could argue that those general principles apply equally here. And as I understand it, the government has sort of conceded as much by saying, oh, well, it's not strict liability on possession, right? You have to know that you possess, right? So we're going to import a knowledge requirement for the possession element. It doesn't seem then such a stretch to say, well, you also have to import a mens rea element as to the status element, right? Because I thought Rahafe said that there's this presumption traceable to the common law that Congress intends to require a defendant possess a culpable mental state regarding each of the statutory elements. So if we're already going to import it as to possession pursuant to Rahafe, why wouldn't we also import it as to the status element?
So.
And I guess the second, sorry, and I'll let you answer, I'll give you extra time, is, are the cases that go the other way, do they predate Rahafe, which is 2019?
All of the cases, state cases I cited, post-date Rahafe.
Okay.
All of them looked at Rahafe and said, notwithstanding the Supreme Court's interpretation of a differently worded federal statute, our state statute does not require knowledge of status. With regard to
those, and sorry, just to pin you down, and those state statutes are similarly or are worded exactly the same as our statute.
Absolutely not. I can't generalize as to their wording. They are not worded identically to the DC statute. I think the closest is the Maryland statute. The Maryland statute says a person may not possess a firearm if the person, one, has been convicted of a disqualifying crime. That's quite similar language. The Maryland Supreme Court in 2022 reviewed Rahafe and found that the intent of the Maryland legislature was not to require knowledge of status. And turning to Your Honor's question about Rahafe, it's true that Rahafe has a discussion of the presumption in favor of mens rea, much like this court discussed in Carroll. I mean, that presumption goes back decades. They found that presumption supported their statutory construction interpretation. So, structurally in Rahafe, the Supreme Court first described the knowingly requirement, found as a matter of statutory construction it applies, and then found the presumption of mens rea supports that interpretation. But every statute is different, and every statutory construction turns on the intent of the enacting body at the time it enacted the statute. And so Rahafe can't possibly control, it was decided in 2019. This statute was most recently changed into its current form in 2009 and was enacted in its initial form in 1953 with the sort of similar language of no person shall possess a pistol initially, and then it was changed to firearm. And so one has to look at the DC Council's intent in enacting that language against the background that in 2009, I mean, this court described it in 2007 as under the statutory scheme that Congress enacted for the district, anyone who knowingly and intentionally possesses a weapon in this jurisdiction does so at his or her own risk. And they didn't put any knowledge requirement, but this court has historically required knowledge of possession. And so the sort of reenactment canon, at the very least, supports an argument that the council understood when it enacted this statute in 2009, how to require knowledge of status as Congress had in the 1953 version. It did not, against a background of one who possesses a firearm in the district does so at his or her own risk. And so the intent of the council in 2009 would not have been to require knowledge of status. And nothing that happened after that can sort of change that earlier intent. If there are no further questions, we would ask that the judgment of the Superior Court be affirmed.
Thank you, counsel.
I'd like to start by revisiting page A24 of the record and perhaps the page right after it. So the bottom of page A24, which Judge McLeese asked me about and discussed with my opponent, the language from Detective Patterson, this is when we get to question 4. And the last question is, are you willing to answer questions without having an attorney present? And then and comma, again, comma, we don't dash, there's not going to dash, we don't bring attorneys in here. Let me just stop right there. Right away, especially the use of again and the sort of, aggressive paraphrasing or abridgment is Detective Patterson is alluding, sort of invoking the oral warning that he gave previously. But as we discussed before, Mr. Green has never expressed any any expression that he understood the oral warning, which is what he needed to understand ultimately, because there are material embellishments. Remember that when he was given the oral warning, his response was, "Is that what's on this paper?" It kind of has that feel of, being in a law school class and you're daydreaming and the professor is telling you some background about the case that's not in the case. And then you get called on, you say, "Are you talking about this case in front of me in my case book?" And the professor, usually the professor would say, "Well, no, I'm asking you about this thing I told you." We're in exactly the same situation. He may have done the reading, but he wasn't listening. And so when Detective Patterson at the bottom of A24 is quite elliptically invoking his previous oral recitation and embellishment, which has never been understood, and there's no factual finding from the trial court that Mr. Green understood the oral embellishment. And so again, we're sort of, we have a very vague, imprecise allusion to something that Mr. Green never understood. And I should add that Detective Patterson doesn't, at the end of these few sentences, says, "Do you understand? Does that make sense?" If you turn the page to A24.1, without a break, he says, "Okay, and sign right here, your signature there, and that's it. You want a cup or something." And so even if this sort of abridged and elliptical invocation of the prior oral warnings would have been sufficient to convey the meaning of the oral warning, even there wasn't a assent or any indication that he understood this clarification or embellishment, or that he or that he understood the sort of the nuances. In other words, there's no reason to believe that Mr. Green thought anything other than, if I 10 minutes into questioning need to talk to a lawyer, I will have the ability to do so. That is the important embellishment that he needed to, the fact that he wouldn't was the important embellishment he needed to understand. And that was never explained to him, at least in a way that he understood or in a way that he indicated he understood. In fact, the record suggests he spaced out.
I know your time is up, but if the presiding judge would permit it, I would like to hear your thoughts on Rahoff.
It's a great and important case, but I think most importantly, and I believe Judge Easterly touched on this in her questioning, that Rahoff does have the initial statutory discussion. One of the things it says in the statute, by the way, is it wouldn't make sense to have knowing for possession and then not no mens rea for the status. And so I think that itself is a sort of response to the government's textual argument, because they're sort of saying
I thought that point in Rahoff was a grammatical point about because in Rahoff the word knowing was used to modify possession.
Yes.
Whereas your opponent argues that as a matter of DC law, the word possess is understood to presuppose a mens rea requirement, because we don't use the word possess to refer to things that may be, attached to us, but as to which we don't intend to exercise dominion and control. So I'm not quite sure that transfers in the way you're suggesting.
That's a fair point, but I think the broader point here is that in Rahoff, after doing that textual analysis, there's like a break in a new section and says, I forget if the word is beyond the text or apart. Actually, yes, this is at page 2196, 139 S court at 2196. quote, beyond the text, we are now going to sort of, our conclusion is also, follows from these sort of basic principles, talking about the presumption in favor of scienter. And I think most importantly, and again, this is even more the case now that we have Bruin, but without the knowledge of the status, carrying, possessing a firearm is often an innocent act. In fact, it's a constitutionally protected act. And so the status, and I mean, the court even italicized status, it's the status that turns possession of a firearm from a right protected by the Second Amendment into a felony with a maximum sentence of 10 years. And the court goes on to say, this is not like these regulatory offenses in which we sort of assume knowledge. I mean, so at the end of the day, I think what the court is saying is we get, especially given the presumption and especially given these principles, it is a question of statutory interpretation, but we absolutely, unless it is excruciatingly clear, are not going to assume that the legislature meant to criminalize something that is in and of itself innocent. And without a mens rea applied to the status requirement, that is exactly what would happen. Court has no more questions. I thank the court for its time.
Thank you, counsel. Thanks to you both for your time, and this case will be submitted. The third case on our calendar today is 22 CO 43 and 22 CO 843. Marlon A. Wilson versus the United States. Counsel.
Good morning. I'm Thomas Seslip, and I'm here for Marlon Wilson, who, as he stood before Judge Lee for sentencing in this case, had not been convicted of crimes of violence on separate occasions, period. And therefore, he did not qualify. The paper served on him did not effectively allow for enhancement of his sentence because his sentences in those two cases were imposed on the same day by the same judge. There it is. Portion of the statute.
Your opponent argues that occasion and date aren't necessarily the same thing. So what's your response? You think occasion is a synonym for date here?
Do I think it's
a synonym for date?
Yeah, conviction means conviction.
I'm not asking about the word conviction. I'm asking about the word occasion. You think that anything that happens on any two things that happen on the same day happen on the same occasion because you're treating occasion as a synonym for date?
Yeah, well, no. I mean, you can make the distinction. I mean, this particular, the facts of this case show that these two incidents happen on the same day, but the government tells you it's not the same occasion. And I think, I kind of agree with that. But the statute here says he had to have been convicted twice before on separate occasions. And that is not true of Mr. Wilson as he stood before the court for sentencing.
Why couldn't separate occasion be one of the sentencings was at 9 a.m., the other was at 1 p.m.? Those are separate occasions, right?
It's clear in this case, you can posit any number of potential absurdities in interpreting this statute. But in this case, he stood before a judge in one proceeding and got sentenced in two different incidences at the same time. That's the same occasion. And therefore, the statute, under any strained interpretation, did not apply to him. The United States wants you to forget the language in C2 and just go with the rest of the statute.
And I think we're just trying to unpack what occasion means. So I think he had two separate judgment and conviction forms. He would have had to have filed, I think, two separate appeals, right? It does seem to me that these were not this was not one omnibus proceeding that resulted in one judgment, but two separate cases that were proceeding on two separate tracks, even if they were before the same judge. And I guess I'm just wondering, why couldn't that mean that each of the convictions was imposed on a separate occasion?
Because it was the same. I mean, I understand what you're saying but he stood in front of this judge, forget which judge it was at the time, and he had been convicted of these two incidences and in the same trial, and he got sentenced for all of the convictions at the same time by the same judge. And if you're saying that doesn't qualify him, I mean, it's not a separate occasion. It can't possibly be considered a separate occasion. And so he didn't qualify. The statute's pretty clear about that. I don't know why the United States, well, I know why the United States wants you to disregard that, but it doesn't make any sense to disregard it. It's.
I just want to make sure I understand something you said factually. You're saying you believe with respect to those two alleged predicate offenses, the defendant was adjudicated guilty based on a single trial that involved both incidents?
Yes.
That's what I thought I understood you to say.
That's what happened. He went to trial, right? He went to trial and oh no, I don't know. No, it wasn't a single trial. In this case, that's what happened.
Understand. I was talking about the alleged predicates because I thought
No,
I thought he pled guilty in those
Yeah, yeah, he
cases.
pled.
There's a waiver of jury trial for
Right, that's how come they got all sentenced at once, but he pled to it and he got sentenced, right? He pled to this, he pled to that, it was a deal. He got sentenced one time. He goes out, and
you
does
say
his
he got
sentence.
sentenced one time. We don't really know, and might depend on who has what burdens of proof. We don't really know on the date of the sentencing for those two alleged predicates, the date those the sentencing or sentencings occurred. We don't know exactly what happened, I gather. But what we do know, I guess, is they seem to have separate case numbers.
Right,
There's separate jury, waiver of trial by jury forms. There's no indication they were consolidated into a single proceeding in the sense of like consolidated cases. So they were treated as separate cases. Whether that should be the test, different question. I just want to make sure I understand what we know about what happened
that
with respect to those. So it looks as though the sentencings, the separate judgment and commitment orders that are created.
well,
So far, are you with me or?
it seems to me that you plead to two things. I mean, probably he got arrested once, released, arrested again. He's got two cases. He settles them both. He pleads. Now he has one settlement in front of one judge and gets one sentence, or gets several sentences, but at one time. His
Well, again, at
convictions
one time-
are nearly simultaneous.
Right. I mean, at one time, nearly simultaneous, maybe. We don't know for sure, but I think it's reasonable to guess, if we were guessing or inferring, that as you surmise, those were two different cases. There was a plea deal that covered both of them. They called both cases at a single sentencing hearing. And the judge, heard about them and then imposed separate judgments on both of them. That could easily be what happened. It's possible it was done in a more rigid way where, okay, let's have sentencing on the first case and we'll do that. And then we'll have sentencing on the second case. Don't know for sure. And it might be that it's the government's burden, if any of that matter, to have shown which that is. But assuming in the light most favorable to you, I would tend to think it seems like, separate original cases arising out of distinct crimes, different case numbers, joint guilty plea pursuant to a single agreement covering both cases, single sentencing hearing, separate sentences imposed in the two cases, and separate judgment and commitment orders. Is that factually what you think in the light most favorable to you the circumstances were? Or do you think-
That's what ordinarily would happen. I mean, I don't think that anybody has pled below that something other than that happened. I think that's what everybody assumed. And I assume it, and I think it's probably in the record that it was a plea deal in the standard way that you do these things. And then you go in front of a judge and you get sentenced for both cases. You've done this crime one day and this crime, I think it was a few months later, 4 months. And you get sentenced for both of them. And that proceeding is your conviction on both cases. And twice before on separate occasions, that doesn't qualify. I mean, that's just it. The language is clear. The government wants you to feel that the statute is ambiguous.
But just to be clear, it sounds like now what you're focusing on is, was there a single sentencing hearing?
Yes.
And earlier, it seemed like you were saying it doesn't matter, even if there were separate sentencing hearings, if they occur on the same calendar day, those are the same occasion. And are you making both of those arguments? So you are.
No. In this case, he stood in front of the judge in those cases and he got sentenced in those cases as a unitary thing. And so
I mean,
he didn't go
again,
back in the
just
back and come back out and get sentenced again.
probably not, but again, whether it's a unitary thing or not, that's, I mean, in a way, that's a label. I'm willing to infer it's likely there was a single sentencing hearing.
Well, I would
All
ask you
once,
then,
But I mean, again, sentenced as a unitary thing, separate sentences were imposed in separate cases and separate judgment and commitment orders.
by the same judge on the same day in the same
Understood. So
proceeding.
it's in some senses unitary and in some senses not unitary. And the question
Well,
is,
what would the
senses matter?
phrase
But just to get back,
separate occasions
I asked
mean?
you, I want to make sure I understand your position.
All right.
And you answered by talking about this case. Is it your legal position that the word occasion means in order for things to be on a separate occasion for this purpose, for convictions to be on a separate occasion, they have to be on separate calendar days? Is that your position or is it not your position?
I think my position is that they would have to, if they were by separate judges on the same day, I think that probably might do it. But I don't know for sure. And that's not what happened here. And so I'm just saying what happened here can't really reasonably be considered separate occasions if the guy's getting sentenced by one judge for two things at the same time. I mean, really, you know,
I guess, counsel, I'm sort of curious, and I'll be asking the government this. How could you ever not be convicted if you have two felony counts? You're being sentenced on both of them. How can you ever not be convicted on separate occasions? It's physically impossible to simultaneously sentence someone at the same time for two different crimes, right?
well,
No?
under current laws of physics, I think that's probably true. But
So what is the point of C1?
C2,
Sorry, C2.
right?
If separate occasions doesn't mean some difference in time.
Well, I mean, it means
I mean, you already have, you would not need C2 or C1. If say a single sentencing hearing occurs, as you say occurred here,
right.
and someone is sentenced to two felonies, and that satisfies the two separate occasions, why do you need the language in C? You don't need it.
You don't need it, but if you're saying that
Because you already have the requirement under A1,
right,
well, the person has to have been previously convicted of two prior felonies not committed on the same occasion. Okay.
right,
So, you know, you commit, I mean, occasion, I think can't mean date, right? Because occasion, if I hold Judge Ali Khan up in the morning and then I beat Judge McLeese up in the afternoon, that's two separate occasions. I mean them no harm. That's
Absolutely.
just hypothetical. But that seems to be two separate occasions, I think, under common parlance, right?
Well, you know, you just have to look at the statute as it used to be under 104A2, where it required that you be sentenced and then, you know, have some period of time where you were going to be rehabilitated, and then you showed you were a recidivist by committing a new crime. And this particular thing seems to be something that tightens that statute up a little bit, but not completely. And you know, it might not be well written as a whole, but that's right there. And if you're going to say, well, occasions mean, you know, the same time, is because the judge didn't somehow sentence him to the
Occasion doesn't have a temporal aspect at all, is what I understand the government to say.
yes. And of course, when you use the word occasion in language, you know,
But it does have a temporal aspect in A1.
in
Right?
A1, yes, they
Clearly.
want to punish people for doing multiple crimes some time apart. Now, I mean, if you look at this case, the one that he went to trial on, suppose the woman hadn't walked away from, second woman hadn't walked away from her backpack, he probably would have gotten convicted of a pickpocket or a backpack robbery there as well. And that means, you know, you have one bar, you have the next bar, another hour or two, and those would be separate occasions. And then he could be subject to life without parole based upon those two pickpockets. And I don't think that the legislature meant that to happen. They meant it to be the case that someone has to have some time between when your convictions count. And that's why C2 is there.
Can I, well, but I guess I don't see how C2 is very well designed to achieve that or any obvious purpose,
I don't-
whichever way you read it. Because if we take for a minute that occasion doesn't mean date, so you could have different occasions on a different date, the hypothetical you gave of somebody gets sentenced in case A before Judge, 1 at 9 o'clock in the morning, and then in case unrelated case 2 before Judge 2 at 4 p.m. You might think, it seems like you're thinking that might be separate occasions of conviction. So
Might be.
maybe. But if the issue is, okay, when is one conviction on a different occasion from the other? Your view has focused on, was it a single sentencing hearing? At least that's one of the points you've made. And I think fair enough, it's not clear that didn't happen here. And maybe it was the government's burden to show it didn't if they wanted to get the enhancement. So we can
Yes,
assume
beyond
maybe,
reasonable doubt, yes.
maybe we could say that's what happened.
Right.
But I mean, it's hard to see what the point of that, if that's how we construe it, like what is the legislature trying to achieve? If assume that's what happened here and imagined that the United States, being very savvy, said, the judge says, I'm getting ready to sentence in these two cases. And the United States says, well, if this defendant is ever convicted again, it's really important to us that these be two separate occasions. And so let's do two sentencing hearings, one on each count. And the defense attorney, being very savvy, says, nope, that's not in my client's interest. We need to have one sentencing hearing. And the judge, should the ability or the sentence of the hypothetical defendant turn on whether the judge decides to have two separate proceedings rather than calling a case, the two cases in a single sentencing hearing? So like, how does that relate to any purpose the legislature would have in terms of what the following sentence should be?
The purpose, it seems to me, would be to allow some time to pass so that you could conclude that this defendant really was incorrigible.
But that's more of I think that's more circling around to your A2 argument about what separate occasions of criminal offenses are, because if your view is that, I mean, imagine in the hypothetical I gave, and even if you think occasion means date, imagine the United States had said at sentencing in these two cases, had said, Judge, we're here today for sentencing on both cases, but we don't want sentencing to be on a single occasion for these two cases, because down the road, we'd like to have the availability of enhancement. So have sentencing in one of the cases today and have sentencing in the other of the cases tomorrow.
Well, I mean, if they did that and the defendant allowed it to happen and the judge allowed it to happen, then they probably would qualify.
And my point is, why should that affect, why would that difference, that the procedures worked out that way? Why would that logically relate to why the legislature would want to punish?
I mean, I'm not saying this statute makes sense. I'm saying that the statute is clear about what is supposed to qualify somebody, and this guy didn't qualify. And so statutes are to be interpreted with some in favor of the defendant, if there are any.
I guess where I'm not quite with you all the way is when you say it's clear about what qualifies, because to me, the word occasion, the idea of when are two convictions in separate cases on the same occasion and different occasions, that's not a question I've ever seen arise in law before. I have no idea. To me, it's totally unclear what those things mean. Or I don't totally clear, but it's certainly not clear what those things mean.
Let's put it this way. If you were the legislature and you wrote and passed this C2 into law, you would surely think of occasions as being different occasions, just like I go to a party on Saturday night and I go to a party on Sunday. Those are different occasions. And they're using language here, which everybody seems to understand, except us lawyers, and occasion means occasion. That means something that happens. This hearing is a single occasion. And if I sit down and then get back up, it doesn't mean that it's a different occasion.
Was the case before you part of the same occasion?
I'm
Was the
sorry,
case before you part of the same occasion?
the case?
The case that
before-
was argued before you,
No, it's separate and
but it's all
distinct.
one hearing.
But you know what? In some ways, it is part of the same occasion. It's the arguments today, right? This is, but we distinguish and we have lines that distinguish these three cases in the.
Well, your opponent argues for a different, it's not entirely clear to me what your opponent's argument is, but one line of thinking in your opponent's brief is that in figuring out whether two convictions are the same, occurred on the same occasion or reflect different occasions of conviction, we should focus on whether there are separate case numbers assigned to them. So the magical dividing line would not be how did the trial court call the separate cases at the sentencing hearing, but instead whether they were treated as separate cases and therefore they would be separate occasions of conviction.
Well,
Why is your view about that superior to their view?
if you make a deal with the government, you have two cases, felony cases pending, you make a deal with the government, the deal is, I'm going to plead to this in this case and this in that case, and we'll go to sentencing all of it at the same time. And the judge gets a pre-sentence report and the judge decides in light of everything that he knows about this guy, including these two incidences, that the sentence should be X. And on the two incidences, that's one unitary sentencing procedure. Even though it involves two cases and two distinct things, the judge is considering all of it, and it's one occasion, one sentencing occasion, not some arbitrarily divided sentencing. Well, because the judge is thinking about all of it, isn't he? He's thinking about, well, you did this on this day, you did this on that day, you know, you have this background, and I think I'm gonna do this with you.
Mr.
I'm gonna give
Hessler.
you this amount on this case.
I think we have your argument, but I think we're showing that we're a bit confused as to how to interpret occasion. So I think that takes me back to the threshold issue you're raising, is that it was ineffective assistance of counsel not to make this argument. And there's a lot of case law, both in our court and the federal courts, that it's not ineffective assistance to fail to raise a novel or unsettled issue of law. And given that we here today can't settle on what occasion means, what is your best argument that this was still a Strickland violation?
Because it was clearly an issue, and if she doesn't raise the issue, she subjects her client to plain error review at this court. I mean, it's pretty clearly an issue. And, it's been an issue for a long time. And I don't see why you didn't look at it. If you read the statute, just sit down, read the statute. We got a guy with life papers. You read the life paper statute, you see C2. You raise the issue. Why? If you didn't read the statute, that's ineffective assistance.
But what if you read the statute and said, this seems pretty ambiguous and I don't think strategically it's a good.
You don't get to decide that. You read the statute and you say, well, wait a minute, maybe this guy wasn't sentenced twice, wasn't sentenced on the same occasion. I better raise this, because if I don't raise it, he's messed over. And so I doubt that. To be honest, I doubt that the statute was read in connection with these papers. But if it had been, and then it was just overlooked, that's not effective. Especially since before they passed this statute, you did have to be convicted on two occasions separate. So, there it's right there. And I don't think you can say as a lawyer defending someone, well, maybe I wouldn't win this. Maybe I will, maybe I won't. I'm not going to raise it. You have to raise it. It's right there in the statute. It seems clear.
Thank you, counsel. We will now hear from the government, and we'll give you some time in rebuttal.
Right. Thank you.
Good morning, Your Honors. May it please the court, Sarah Hansen for the United States. The trial court did not err in rejecting appellant's ineffectiveness claim. he can show neither deficient performance nor prejudice in his counsel's failure to challenge the application of section 1804 alpha's enhancement provision to his sentence in this case. From the government's perspective, the sentencing enhancement scheme at issue here did clearly apply to Mr. Wilson in this case. First and foremost, we can dispose very easily of the question under subparagraph A2, where he very clearly did commit 2 prior crimes of violence on separate occasions. And it is the government's position that he was on separate occasions convicted of 2 prior crimes of violence pursuant to subparagraph C2.
So what does occasion mean?
Well, this court has defined the term on more than one occasion in US v. Smith as acts that have occurred at 2 or more distinct times, with some time separation between them.
So it has a temporal aspect.
Yes, Your Honor, we believe
Okay.
so.
So how is it that someone could be convicted of 2 felonies not on separate occasions?
Well, so.
In the same, if you have a single sentencing hearing,
Yes, Your Honor.
as apparently you do in this case,
Mhm.
is it possible to have a felony conviction, those 2 felony convictions not on separate occasions?
Your Honor, I think that the
I guess
question-
my point is, why do we need C?
I think the purpose of C2, Your Honor, is to preclude.
C1 or 2, right? Because they both have the same language,
Yes, Your Honor. but Yeah.
right?
although the
Why
C2
not just say, hey, this provision applies if you've committed 2 prior felonies, not on the same occasion? Period, full stop, we're done. There's
Essentially-
no other restriction, right? We don't care about when or how you were sentenced.
So
You committed 2, sorry, let me just
Mhm.
finish, and then you can have a time to respond,
Of
but
course, Your Honor.
you committed 2 felonies on 2 different occasions, and so therefore the statute applies. You don't need C. I don't see a need for C, so I'd love to know what the
Of course, Your
purpose
Honor.
of C is.
The government's position is that the reason that the subparagraph C portions exist is to preclude imposition of the sentencing enhancement for 2 felony convictions that exist within the same case. So
Why does it matter? We've already told, the statute already says in A, if you committed them not on the same occasion, then
because the commission and the conviction are 2 separate questions, and it's our position that that's why the DC Council drafted the statute the way that they did.
wait,
where the-
I guess I didn't understand what you said. Can you say again? It's so that if you get convicted of 2 felonies in the same
In the same
case.
case, Your Honor, that those would not be the basis for, under the statutory scheme as it exists now, those
But,
wouldn't be the
well,
basis
but-
for the.
but
sentencing
isn't the
enhancement.
limiting factor, right? So they're in the same case. So I get charged
Mhm.
again with robbing Judge Ali Khan, committing felony assault
Mhm.
against Judge McLeese.
Okay,
Right? 2 felony convictions.
yes, Your Honor.
And that the important thing is that I did it at a different time, right? It's not that they're standing right next to each other and I beat up Judge McLeese so I can hold Judge Ali Khan up, right? It has to be at a distinct temporal time under A, right? I could be convicted of both of those, but those, unless I do that at different times or different occasions.
Correct.
Right,
And
which is a
that-
temporal distinction, the statute does not apply.
Yes, Your Honor, I think that's correct, that if
Right.
in your hypothetical, let's say, just for sort of ease of reference here with the facts, that the first felony took place, like your hypothetical before at 9 in.the morning, and then the other one took place in the afternoon. So they're clearly distinct temporal occasions.
Right, so
But if
they're
they're-
in the same case.
But if for whatever
They
reason
get
they're in the same
charged,
case,
They get charged together, I get indicted for both
correct, Your Honor.
in the same case. Why do I need C to say it's still okay for the statute to apply to me? I already have A saying they were on 2 separate occasions.
Well, I would argue, Your Honor, that C2 would say that the statute wouldn't apply to you, because if those 2 convictions were entered in the same case, the judgment in that case is entered for those 2 charges at the same time. So for purposes of paragraph C2, that would be 1 conviction, even though it's 2 charges.
And the
you have one-
hypothetical would change if it was originally charged, well, three pictures. There's the hypothetical you gave, which is there are two distinct incidents. They're
right.
charged in a single case.
Mhm.
So it's fine under A2.
Correct.
But you're saying if it stays as one case, goes to sentencing, and in a unitary sentencing proceeding, judgment is entered in that case, that means disqualifying under C2. Is that
Correct, Your Honor,
right?
because I
But
mean, it would be a unitary sentencing proceeding, and that it would be a sentencing hearing in a single case. a
Understood.
single
And so
matter.
now, how about if before trial, those two cases are severed
Mhm.
and they, but let's assume for a moment, they're not given separate case numbers. So the two charges are severed for trial. One is tried first, the other is tried second. And let's say to spin out the scenario one way, the one that is tried first goes to sentencing. And then later, the second one is tried and goes to sentencing. So you have sentencing hearings that are months apart. You would say, as long as they are given the same case number in Superior Court, C2 disqualifies them.
No, I think the hypothetical that you've given is a little bit of a more difficult question, but is not the case that occurred in, that is not. the case
It's
that
certainly not the
occurred
case here, but so
I-
are you saying that one way cases, convictions can be on separate occasions is if they have different case numbers?
That's correct. Your Honor.
Another way, though, is if they're in a single case number, but they are separated in time. Is that what your position is?
I think that's possible, Your Honor. I think that essentially what the government is arguing is that when convictions are in two separate case numbers, they are necessarily separate occasions.
What policy objective does that serve?
I'm
Right,
not sure.
Judge McLeese was talking about, sort of or there was some discussion earlier about policy objectives. And I'm trying to understand what your argument about case numbers, what policy why would
Do you mean
the
in terms of what
council-
sort of the legislative intent would have been? In
why
putting
would
that
they
into
have
place?
wanted to make
Sure.
that distinction and say, hey, we want to punish this person who serendipitously gets indicted on two distinct charges and wisely does not move, for misjoinder, right? That person doesn't get hit under the statute, but the person in Judge McLeese's hypothetical, they're going down.
I think, Your Honor, the purpose of that is because just to suss out what the DC Council intended by putting the statute in place the way they did, I think it's useful to look to the history of the statute and how it was enacted prior to the way that it's phrased now. The previous version of the sentencing enhancement scheme, when it was previously codified under section 22104A, before it was substantially revised in 1994, did have a very clear temporal requirement, which opposing counsel.
Well, I thought you
referenced.
said that there's no doubt that this statute has a temporal requirement, right?
Yes, but it had a very clear different temporal requirement where it specifically required that the conviction for the first crime that formed the basis for the enhancement the conviction had to occur prior to the commission of the second offense.
Right.
And by changing the statute to get rid of that requirement, which they affirmatively considered and declined to include, and instead including this more permissive structure, but that still includes protections to ensure that the commission of the offenses are distinct and also that the convictions are distinct. Evidence is the legislature's intent to allow the sentencing enhancement provision to apply to a broader range of offenders than the previous.
Sure, it's broader, but I don't understand why you think that supports the argument that we don't really care about the scenario here. That you would say, even though they're sentenced at the same time, that Mr. Wilson is sentenced at the same time, that's two separate occasions.
Because I think, Your Honor, the purpose of the statute is to allow for sentencing enhancements against offenders who are repeat offenders and with respect to the A2 and C2 repeat violent offenders.
Right,
And
but that
so-
takes me back to my question of if all we're concerned about is repeat offenders, we have A. And A says you can convict, if a person is convicted of having and they've been previously convicted of 2 prior crimes of violence not committed on the same occasion,
Mhm.
this statute applies to them. You already have that. So what work is C1 or 2
Mhm.
doing?
Well, I guess I'll refer back to what Your Honor noted with respect to, I think you used the word serendipitously, that some cases have offenses that are distinct in time but are charged together and other cases don't, or they move for severance or whatever the
I
case.
may have misspoke.
maybe.
That happens with some frequency.
Yeah, but I think ultimately to the extent that that offenses that occurred at separate occasions are ultimately brought together in a proceeding, they have to have some kind of intertwining relationship with one another, or the defendant would have been able to successfully move to have them severed. And so
Well,
Given-
why is that the case? If, I mean, maybe, I'm not sure that's true even with felonies. So, 2 completely distinct, again, if you have a single defendant and 2 felonies of the same kind
Mhm.
that are committed on different days can be joined under Rule 8A if they're the same or similar in character. They don't have to be factually connected otherwise. So I don't know that I'm not quite sure that.
I take Your Honor's point. I guess what the point that I'm trying to make is that it's the government's position that the purpose behind C2 is to establish that felony offenses, even if they are committed on different occasions, if they are disposed of in a single proceeding.
And what's
that they
that, and the big dispute, or one of the disputes is that in figuring out proceeding, do you look at case number or do you look at like how the case was called and how the sentencing
Mhm.
proceeding worked? But, and this will give you one other hypothetical back.
With respect to the facts before this court in this
Before you get
case,
to the facts, I just
we-
want to make sure I understand your position about another
Yes,
hypothetical.
yes,
So
Your Honor.
imagine that there are 2 cases that are, the defendant is charged with committing a particular kind of crime on date, in case number 1 on one date.
Okay.
And then case number 2, different case number, same type of crime, is charged, felon, both of them, let's say, qualifying felonies. So they're originally separate cases and a motion to consolidate is filed. So they are consolidated for trial, but they still, it's not like you will change their case numbers. And then they are tried together and at a single sentencing proceeding,
Mhm.
there is a single judgment, I mean, a single in some senses, single pronouncement of sentence, and then the 2 judgment and commitment orders are entered. You would say those are properly predicate offenses because the case numbers, they were 2 case numbers, although they were consolidated for trial, whereas I gather you would say if they were never, if they were charged originally under a single case number, they would not be qualifying convictions. Is that right?
I think that that's a more difficult hypothetical than the facts before the court in this case. And I
But
think
we'd
what,
love to hear your answer.
and I'm, to be honest with you, Your Honor, I'm not willing to commit to an answer to that hypothetical because I think that that's a harder set of facts than the
Right,
court
but
is called
we're-
upon to
we're-
decide.
It's
And-
not about, well, it's helpful to get responses from the government about where the line is.
I understand, Your Honor, and I don't think that there is I think as a general bright line rule, when there are 2 separate proceedings, 2 separate case numbers, that the sort of baseline requirement of separate occasions for conviction has been met. That's not to say that there may not be cases where, given the circumstances surrounding those 2 cases, such as the hypothetical that you just presented, might present a harder question if it were to be presented to a judge at the trial
And your opponent
stage.
is taking the view that this is one like that, really, where, because it all became a different proceeding. Can I
course.
ask you, I want to clarify a couple things first. The word in C2 is conviction. That's sometimes an ambiguous term.
Mhm.
Sometimes it is used to refer to the adjudication of guilt, sometimes to imposition of sentence. I think the parties have both taken implicitly the view that we should be interpreting that to mean the imposition of sentence rather than the adjudication of guilt. Am I right that that has been your assumption, and is it your just?
Yes, Your Honor. I think that the way the government is interpreting, I can't certainly speak to Mr. Heslop's interpretation, but the government's interpretation is that the conviction attaches at the time that the judgment is entered and sentence is imposed.
And relatedly, we know some about what happened with respect to the understanding conviction to mean imposition of sentence. We know some about what happened. It seems like there was a guilty plea and the like. We don't know everything.
No,
at
Your
least in the materials that we have. And in the questions I was asking your opponent, I was suggesting perhaps that that means we should infer for current purposes, what would be most favorable to him, because the government would have borne the burden of showing the appropriateness of this, although maybe the ineffective assistance of counsel prism complicates that.
Mhm.
But do you think it's fair for us to assume that what happened here with respect to the two predicate offenses is that the judge called a single sentencing here, you know, called both cases at the same time, had a sentencing hearing where both were addressed, and then, you know, announced sentence in both cases all in one sentencing hearing on a given day? Do you think we should
Sure.
assume
I mean,
that?
I think that's a fair assumption to make, because practically that's often what happens in the context of a global plea. I will note that in light of the fact that this whole conversation about the applicability of the sentencing enhancement provision is in the context of an ineffective assistance of counsel claim, would indicate that the burden would be on the appellant to show that the counsel at sentencing for Mr. Wilson was ineffective, which it's our position he has not done, because he hasn't demonstrated, as the court pointed out during his questioning, that she was deficient in her performance in failing to raise this.
And how
This
do you
issue.
assess that? What's the measure of that? Does it have to be a slam dunk, and the fact that we are confused suggests that it wouldn't be ineffective? Or is it, if it's a viable argument, there's an obligation to raise it, whether or not it might ultimately prevail?
No, Your Honor, I think in his argument, opposing counsel sort of hinted at the fact that the opposing counsel may not have even read the enhancement statute and sort of didn't have a sort of baseline awareness of of its meaning. And the record before the court makes clear that that's absolutely not the case, and that she did understand the sentencing enhancement statute and argued as effectively as she could for her client in the sentencing hearing, particularly as it relates to the issue of the statutory minimum versus what the appellant alleges is the misapplication of an alleged mandatory minimum. So I think that the sort of bottom line for the court to consider, and I want to be conscious of the fact that my time's expired here, is that he's failed to establish that she was deficient in her performance by not raising this issue, which from our perspective, on the face of the statute, if you read it, is clear did apply to her client. And he certainly also hasn't met his burden to demonstrate any prejudice to the client in light of the representations made by the trial judge about the reason for his sentencing over and above the requirements of the sentencing enhancement statute itself, as it relates to the defendant's prior history of 21 similar offenses, et cetera, et cetera.
Counsel, can I just ask you one more question? And then
Of course, Your Honor.
we'll let you sit down. But the government's theory of case number theory of occasions,
Yes, Your Honor.
is that supported by the legislative history? And where does that come from?
I can't say that it's explicitly supported by anything that we found in the legislative history, Your Honor. The legislative history doesn't speak explicitly as to the reason behind the specific wording of that portion of the statute that I was able to see. I think the government's assertion that that's how the statute ought to be read is because that's a reading of the statute that we think comports with both the intention of the legislature as can be inferred from the statutory scheme as a whole, and the difference between that scheme and the prior version of the scheme, as well as from a practical perspective, how the two paragraphs can be read in tandem with one another and in concert with one another to bring that legislative intent into effect.
I'm sorry, what legislative intent?
Of the statutory enhancement scheme as in general to impose punishment enhancements on repeat offenders. So it's our assertion that, recognizing that while there on its face may be some tension between those provisions, we believe that the reading that we've asserted is the reading that makes sense.
Not to feed a fed horse, but why is there tension between the two provisions?
Well,
I mean, why couldn't you just read it literally and
Well, I
say, in order for this provision to apply, you have to have committed two prior felonies, not on the same occasion.
Mhm.
And you have to have been convicted of two felonies, not on the same occasion.
I take your point, Your Honor, and I,
It seems like those could be read and it just layers on and it makes the statute more limited in scope.
yes, Your
But
Honor.
it doesn't seem like it's more limited in scope in any way that's clearly in tension with anything that the council said when it amended the statute.
I don't disagree, Your Honor. I think that my reference to the fact that that on initial reading, there may appear to be some tension between those paragraphs is a reference to the fact that that's what this court noted in Mr. Wilson's direct appeal when he raised the issue of the applicability of the enhancement statute to him. And the court acknowledged what he characterized as.
Do you
and-
think we're bound by that?
No, Your Honor, I don't. And I think that
If on further reflection, we don't see any tension.
no, Your Honor, I don't. And I would just note that, I guess, my reason for phrasing it that way is to the extent that the court does believe that there is some tension between those two paragraphs, it's the government's position that they can be read in concert with one another to effectuate the legislative intent.
Thank you.
Thank you very much. And if there are no further questions, we would ask that the court affirm the judgment of the Superior Court.
Thank you,
Thank you.
counsel.
If this statute isn't ambiguous, then Mr. Wilson gets his 13-year sentence at least, and not the 15-year sentence. If the statute is ambiguous, then the rule of lenity tells us that we have to give Mr. Wilson the benefit of the doubt, and he gets his 13-year sentence and not his 15-year sentence. That's really all I have to say. It looks to me like, based on this argument, statute in the consideration of this court sounds to be ambiguous based on the word occasion.
Thank you, counsel. Thank you both for your arguments today. And the case will be submitted and this court stands adjourned.
Oh. This honorable court is now adjourned.
Really, they just messed up.